So I'd like to welcome you all to our webinar, which is the launch of our publication from the Pretrial Justice Institute focused on the racialized history of misdemeanors. And I'm Megan Guevara with PJI, and I'm joined by my colleague, Kevin Beckford. We're going to be facilitating a conversation today that we're really looking forward to. PJI got into the subject of misdemeanors knowing that it is really the driver of the pretrial process, that such a large percentage of people who become involved in pretrial justice, it is because of being charged with a misdemeanor. And so this paper and this conversation gave us the opportunity to explore that history and also to look at what the next steps are to be able to do some repair for the challenges that we face in the misdemeanor process and some of the harm that's been done. So we're really looking forward to this conversation. We hope that all of you who are joining us today will participate through the chat. Please feel free to ask questions at any time and to add your comments, though we do hope that this will be a safe and anti-racist space for us to be able to have that conversation today. And I am joined by my colleagues as well, Ivana Crow and Wendy Shang, who will also be hanging out in the chat box with all of you. Wendy will be sharing resources as we go through the conversation, and Ivana will be making sure that we make note of all of your questions, and is also here if you have any technical difficulties that you need us to help you out with. And with that, I will hand it over to Kevin, who is going to get us started today.
Thank you so much, Megan, and thank you to those who joined us today. PJI is committed to engaging in this critical conversation because endemic racism pervades the misdemeanor system, obstructing pretrial procedure, and something must be done. A misdemeanor is considered a crime less serious than a felony, and the punishment is supposed to be acceptably less harsh, usually less than 12 months in jail. Data consistently shows a disproportionate representation of Black, Indigenous, Latinx, and other underserved individuals in misdemeanor cases. The majority of individuals awaiting trial in the US facing misdemeanor charges, accounting for 80% of court dockets nationwide. Many of these charges have origins linked to the racial history of the criminal justice system. The escalating quantity of misdemeanors in criminal code continues to disrupt the pretrial procedure without enhancing public safety. Within the system today, we see that the manner in which the criminal legal system handles misdemeanors is in disarray, swamped with enormous caseloads, offering minimal protection for the innocent, and disproportionately affecting Black and Brown communities. The COVID-19 pandemic exposed the gross extent to which inequity and racism compromises the legal system. Now, as the pandemic raged on, some communities across the country made the decision, for example, to proactively decrease misdemeanor arrests, leading to sharp declines in jail populations without compromising public safety. Paradoxically, people who are arrested for misdemeanors were spending months awaiting disposition. Many are still waiting because of the pandemic-driven court backlogs. The disproportionate representation of Black and Brown people who are detained further shows us that racism is in fact pervasive in our system. Today's discussion, synchronized with the release of PJI's paper, Unjustified, Reckoning with the Racialized Legacy of Misdemeanors in the United States, which we are excited for you to read, explores the historical context of misdemeanor offenses and their impact on the pretrial process specifically. The paper also discusses relevant reforms grounded in anti-racist principles. We purport that these anti-racist principles require partnership between system and community members and the collaborative pursuit of solutions grounded in equity, accountability, and safety, rather than punishment. We are excited to explore the historical and ever-present dynamics and challenges around misdemeanors today with an esteemed panel of experts and practitioners. Today we have with us Kayla Vincent, the inaugural executive director of the Yale Law and Racial Justice Center, Alexandra Nadapoff, a professor at Harvard University and an award-winning legal scholar and criminal justice expert, Mano Raju, the elected San Francisco public defender. Joining us, we will also have Anton Robinson with the Defender Association of Philadelphia. And last but certainly not least, Rosemary Nadiri, the senior counsel in the justice program at the Brennan Center for Justice, Previously, Rosemary served as a Deputy Director of Fair and Just Prosecution, and she served for a decade and a half as an Assistant U.S. Attorney in the Southern District of New York. Panelists, thank you so much for joining us. I want to begin our time with the following question, and if you can answer it briefly, and we'll begin with Kayla Vinson of the Yale Law and Racial Justice Center. That question is, from your research or experience, how do local policing practices and court cultures and the criminal justice system at large contribute to the perpetuation of racial disparities in misdemeanor arrest?
Thank you, Kevin. Thank you to everyone at PJI for hosting this conversation and bringing us all together. I think I'd like to answer this question with a story about when prior to becoming an attorney, I was a public school teacher in New York City. And I was teaching in East New York at an alternative high school that had opened really with the goal of offering sort of a last chance at a high school diploma for young people, most of whom had either dropped out of middle school or been kicked out of middle school. And so our students were making the choice to come back and get their high school diploma. And there was one student in particular, attendance was always a major concern for us. Sometimes our students had a lot happening in their lives and coming to school was challenging. And there was one young man who was the one student who was there almost 100% of the time. He was excellent academically, really a star student. And maybe a month or so into the school year, police officers came to our building after school, asked to speak to his teachers, and told us that he was on their radar, that we shouldn't bother trying to educate him because they were doing what they needed to do to get him off the streets. And so for a young person in New York City who was trying to do his best to get his diploma, we can imagine all of the things people might say to him and about him if he did end up entrapped in the system. The police were asking his teachers to give up on him. And that was in large part due to the fact that he had an older sibling who had been involved in the system. And because he hung out with his brother, he was deviant and needed to be arrested. And so I think, from that, it was less about whether or not their experiences with him were factual and more about the fact that they were determined to make sure we didn't see him as anything else and that he didn't have the opportunity to become anything else, and that he was a part of a behavior management system that they were in charge of. And so just thinking about what it meant for young Black and brown boys and girls to try to get a high school diploma in a place like East New York, I think shows us the ways that cops and the system can often act in ways that discourage access to opportunity for young people.
Thank you for sharing that very powerful story, Kayla. Alexandra.
Thank you, Kevin. Thanks to PJI for your important report, shining light on really the vast bulk of our criminal system. I'll just begin by celebrating the fact that we are finally talking about what it is our criminal system really does to the most people, most of the time, every day, millions and millions of times, over and over, and yet we have historically not paid attention to it. It's really only been in the last decade or so that we have started to see data, to see scholarship, to see advocacy like the PJI report, focused on what the legal system and lawyers so often write off as petty, as minor. We literally define these offenses as petty and minor, but they are anything but for the people who are touched by the criminal system. The misdemeanor system is the first step in the criminalization of so many Americans. It is why we have such an enormous criminal net that famously sweeps in more people and a higher percentage of our population than any other Western democracy. It is the first step in the racialization of crime in this country. Kevin, you asked about policing. What is the relationship of policing to misdemeanors? It couldn't be more important. It is those policing decisions that bring people in to the criminal system, as Kayla's story so powerfully demonstrated, is also the first step in the way that our criminal system dehumanizes millions of people, reduces their worth, reduces their life chances, and reduces their ability to function in their families and their communities and in the economy. So it couldn't be more important to be having this conversation at this moment. And thank you so much for including me.
Thank you so much for joining us. Mano, are you able to share your thoughts?
Sure. By the way, it's Mano, accent on the second syllable. But there's many stories I could share, but I'll share one. I'm now the elected San Francisco public defender. I used to practice across the Bay in Contra Costa. And I'm going to talk about a case where I had a young client, 18 years old, going through the woods. He had a branch in his hand, sees a cousin, and the cousin's on a little scooter. And he says to the cousin, "What are you doing? You should be in school right now." And the cousin says, "You're not my dad. You can't tell me what to do." And my client, like, jokingly, with a backswing of the branch, says, "Well, if I were your dad, I'd hit you with this branch." Unfortunately, on the backswing, he scratched the cheek of the cousin, runs to the cousin's house to see if he's okay. But that didn't matter to the prosecutor in our county. They charged him with assault with a deadly weapon, which is a strike in California. And the geography of that county, like literally, if that case were in another part of that county, they might charge that as a misdemeanor. If it's another part of the county, they call the parents and say, "Hey, this thing happened. Can you sort it out?" But because of where it happened, it's charged as a felony strike, right? And then the client's in and they're offering, we'll drop the strike, plead to a felony, you can get out today, that kind of thing. And that's just a cycle. And we see that in so many different areas. And on top of that, I'm so glad we're having this conversation, because so much of the conversations about the need for change focus on the client who's doing 30 years, or the death penalty case, we find the missing piece of DNA, now this person's off death row or whatever it is, or already convicted, and but there are wrongful convictions happening in every single county across this country every single day, and it's misdemeanor pleas, and they're happening there's 130 calendars about to be called. There's a bunch of people who are going to be wrongfully convicted right now, in every pretty much county in this country, I would say. And another practice is often for a prosecutor to say, "Well, I charge this fellow, we'll just plead to a misdemeanor." When there's a lot of strong evidence in our favor, we think we're going to win the trial. Then the move oftentimes is, "Well, just plead to this misdemeanor." And I remember one time a judge saying, the district attorney was frustrated that the public defender wouldn't plead their client to the misdemeanor. And the judge said to the DA, "Well, how many misdemeanors do you have on your record? Like, if it's such a minimal thing to just plead to a misdemeanor." And of course, when the light is shined back on the prosecutor, she's wasn't that comfortable with that question. But yes, it is something we really have to wrap our hands around. And at least from the public defender perspective, one is, I think we have to start shifting a lot of this stuff to not be there. But in the meantime, as long as we have a backlog right now in San Francisco, where there's literally 1,000 cases past the last day in misdemeanor courtroom, because they've been trampling our clients' speedy trial rights. It caused me to actually sue the Superior Court in San Francisco because of that. We've gotten some relief now in the felony realm, but we haven't gotten realm in the misdemeanor realm right now. And we know the majority of the people entrapped in the system are BIPOC. But it's really time to have a real discussion about this. And I'm looking forward to doing it all with, really grateful to PGI for facilitating this and the great article that came out.
Thank you so much. Rosemary, you have an extensive career and background in essentially fighting for the establishment of justice. I'd love to hear your thoughts on this question.
Thank you, Kevin, and thank you to PJI for having this important conversation, and also to all the panelists who've already spoken and shared their very, really insightful thoughts about this question. Look, I think we've created a system where, to be candid, policing and prosecution, what I'll just call our punitive enforcement, is our default go-to fallback response for a whole array of societal failures that were built on our history of racially disparate policies, laws, and investments. So public health inequities, social investment inequities, education, employment, housing inequities, all the ways that these manifest show up downstream. And unfortunately, our default solution to the societal problems arising out of all of these historic investments, such as mental health issues, homelessness, substance issues, even as was, potentially acting out in school, is the criminal justice system. We call the police and we expect the police to respond and do something. And often police, prosecutors, departments, these agencies are evaluated and judged by metrics, and importantly in our public conversation, by the number of arrests, charges, convictions when they're called. They are expected to do something, and they often turn to the only tools that they have. Now, that's not to say that they couldn't handle these things differently, that, there are other responses that are possible, deflection or diversion to treatment, services, housing options, but the investment that we have put as a society in those options, I'm not even going to call them alternatives. Those are, really should be our first options. It's exponentially less than the investment that we put in punitive enforcement. And I think also our overall media and public conversation still prioritizes arrest, prosecution, conviction as the paradigm solution to a lot of these, a lot of the ways that these problems manifest themselves in our daily lives. So, I think just as one example, in today's conversation about prosecution, for example, prosecutors' offices, especially those that are attempting to take a more reform-minded approach to their role, are often criticized for having too many dismissals of cases. And I think that all of these different stresses kind of push us all, and I'm talking, just the pressures on police and prosecutors to make ultimately the wrong choices in these situations, but it also already starts with our kind of overall, the options that we kind of offer out there for solutions to these problems. So I think the system itself and our societal expectations and conversation perpetuate these disparities. And I think that this conversation is really important to really engage communities and all of these different stakeholders in figuring out how we can solve that.
Thank you so much, Rosemary. Anton, if you could share your thoughts.
Sure. Thank you, Kevin, and thank you to PJI for having me, and to the other panelists. Really excited to share this virtual stage with you. I am coming to you from the Defender Association of Philadelphia, and I know that some of you saw that I was formerly at the Innocence Project. And I named that purposefully to sort of note that I come at this from various vantage points, from that of a criminal defense attorney, a former public defender. I've done some policy work as well, and again, am in a public defender context. And the most important part of the work that I've done has been working with people. Sitting across from people sometimes on the hardest days of their lives, in arraignment court, right before we go before the judge, and then sitting with them for sometimes years, as we work up their cases and try to get the best disposition for them. What that has done for me is it has reminded me of what is important and what is at stake. And it is about people. When we think about the criminal legal system, there's so many ways that we try to put some distance between the people who appear before judges and other people, but we are all here, and the research shows that all of us have close family members who have come in contact with the criminal legal system. So a big part of my job as a defender, a big part of my job at the Innocence Project, was to make sure that everyone understood that this is a person with complex issues going on, with life circumstances, with health issues, with mental health issues sometimes, and to really, really come to it from the context, or excuse me, from a perspective where we look at a person as a whole. And I see that as a big part of the job when we're thinking about alternatives to incarceration, which is to think about the actual needs of actual people. And I know that sounds so basic, but that has been a big part of my job as a defender. It will continue to be how I sort of see my career, but it's also why I'm super excited about this report, is because in some ways it calls for the readers, it calls for system actors to do just that. So thank you for having me and inviting me to this conversation.
And thank you for being a part of the conversation. I can tell this is going to be a powerful, and it for sure is a much needed conversation to have. And before we delve in deeper into some of the modern day challenges and issues around misdemeanors, it's important for us to look at the history as it pertains to race and misdemeanors. In his book, Slavery by Another Name, Douglas Bachman talks about how the courts in the rural South worked before and right after the Civil War. I want to kick a question off to Kayla, and anyone feel free to share thoughts around this question. How has the legal system been used historically to recreate structures reminiscent of slavery, especially post-Civil War? And how do these structures manifest in today's misdemeanor system? I want to tag along to that question. How do you see the historical trajectory of the misdemeanor system directly affecting the contemporary experiences of specifically Black Americans?
Yeah, thank you. So I think that in order to really think about the rise in the misdemeanor system after the Civil War, we have to talk a little bit about what slavery was as a legal system itself. I think sometimes we think about slavery and we think about its sort of its core characteristic, which is the legal ownership of Black people. But as a legal system, it was really a lot broader than that in order to sort of effectuate white political, economic, and social control. So slavery was also an economic system built on ideas of white supremacy and racial subordination that became the means through which individuals and institutions built their own wealth and power. Some of them did that as enslavers, others as businessmen involved in slavery and the slave trade, and some made their living surveilling and managing enslaved people on behalf of owners. So it was really a means of economic security, a way that some people paid their own bills. It was also, as a legal system, an attempt to strip Black people of any authority over their own lives, suggesting that Black people were inferior to the point of being unable to manage their own lives, that they could be separated from their families at will, prevented from moving through public space without fear of being stopped, questioned, and forced to justify their presence in that public space. It was a system that permitted and encouraged race-based suspicion of Black people. It really relied on fear-mongering about what Black people would do if not kept under constant control and surveillance. And because of that, it relied on punishment, less of a way of condemning individual harmful behavior, and more as a way of signaling to the punished and the witnesses who had rights and who didn't, who was protected and who wasn't. It was a way to enforce the submission to the legal system of slavery. And so when we think about all of these things that the legal system of slavery required, it becomes really easy to see what happened after the Civil War as an effort to recreate the conditions of slavery through a new legal system, that system being the criminal legal system. So after the Civil War, if you could deem a Black person a criminal, you could justify all kinds of economic, political, and social control over them. There are new laws written, especially in the South during this time period, that targeted Black people. Some of them even in the text of the law only apply to you if you were Black. And they provide a new legal means for restricting what freedom might mean post-emancipation. So the misdemeanor system that we have today, where people are frequently stopped, arrested, prosecuted, and punished over minor, often non-harmful behavior, became a significant feature of American life when it could be used to preserve the economic and political relations of slavery. So some of these laws, often sometimes called Black codes, were laws that charged Black people fines. And then if you could not afford to pay, as many newly freed people could not, you were then punished for failure to pay by being sold off to land or business owners to work for them as a way of being punished for not being able to pay the fine. Some of these Black codes included things like, if you were Black, holding a meeting without first getting the permission of the police, being idle or unemployed, missing a day of work, making an insulting gesture in public, or handling money carelessly, whatever that might mean. So some of these are things that we might think of today as a part of order maintenance or broken windows policing and prosecuting. And they really have a long history that traces back to the South after the Civil War, where criminalization was used to restore order. But of course, we have to remind ourselves that the order that they were restoring was that of white supremacy. And this rise in the system was not about crime control. It was not about public safety. And we know that because at the same time that Black people were jailed and rented out to local corporations for things as non-harmful as missing a day of work, white mobs across the country were hanging, shooting, burning, and mutilating Black people in public lynchings with the support of local law enforcement. And fewer than 1% of those who participated in a lynching mob ever faced criminal accountability. So the boom in the criminal legal system didn't reflect an increase in crime, but rather a response to Black freedom. And that's not just a 19th century story. It's also a 20th century story, because the rise of the modern criminal legal system, what we often talk about as mass incarceration, and the misdemeanor system that we have today, also what didn't reflect an increase in crime, but rather a response to the winds of the Black freedom movement of the 1960s and the fall of legalized slavery. So many of the features of the system that we think of as sort of natural or inevitable today were initially designed as a part of a scheme to restore a system of white power through Black subordination. So I'm talking about things like the very wide net that the system casts, its indifference to innocence, where it's really punishment is the point, the exorbitant fines and fees, where sometimes the fees are multiple times what the initial fine was, the racialization of crime, which teaches us to link crime and race in our thought patterns, which in fact, the idea of a Black crime rate emerged as a tool of social science in the late 19th century alongside the misdemeanor system. And although many misdemeanor arrests don't lead to convictions that include jail time, some are about probation and other forms of surveillance, many people are detained in jails pre-trial and also post-conviction, and those jails are dangerous and sometimes deadly. So during the post-Civil War, death was a tolerable feature of the misdemeanor system. Historians have described chain gangs and convict leasing as worse than slavery because of how often people died because they were being forced to labor as for failure to pay fines. And today, when people can't afford bail, they are sent to to jails with deplorable and inhumane conditions. People likely have heard stories about places like Rikers Island in New York City, but there are also places like the Fulton County Jail in Atlanta, Georgia, where 10 people have died in that jail this year alone. So I think that when we look at the history of the misdemeanor system, it gives us insight into how and why the system operates today and the ways that it targets the vulnerable and then deepens that vulnerability and really puts the onus on us to figure out how we're going to have a system that isn't so shadowed by the previous system of slavery.
Kayla, thank you so much for that historical grounding and really a reminder that we are working with a system that is operating as it was intended and as it was built. And if we want to do something different, then we have to consciously dismantle what has been being constructed over the past 150, almost 200 years. And so I'd like to take a look now at that modern system and to turn to Alexandra, and your book, Punishment Without Crime, was really a wonderful reference for us as we were putting this paper together. And you talk about the modern system as being enormous, sloppy, and fast in terms of how we deal with misdemeanors. And can you elaborate a little bit on that description, and specifically on the impact on Black, Latinx, Indigenous, and other people who have been marginalized by the system and continue to be marginalized by the system?
Thank you, Megan. I want to pick up on a thread that was started by Rosemary and Kayla to understand the criminal system generally, and then the misdemeanor system, which of course constitutes the vast bulk of the criminal system, as a socioeconomic institution in its own right. It redistributes wealth, literally through fines and fees and wealth stripping and the regressive taxation. It redistributes labor. It prevents people from functioning in the workplace, in the labor market. It devalues their ability to work. It redistributes status. There's nothing really like, carrying around that mark of criminal stigma, like a criminal record. And it is, in that sense, the destructive counterpart to the rest of our social safety net. It takes away what our education system strives to give. It takes away what food stamps and welfare and job programs and other programs designed to lift people up purport to give. In other words, that it's, as it were, the right hand of our governance system is taking away what the left hand is trying to give. And so when we understand it that way, it's the criminal system is not just an adjunct to society. It's not a side hustle. It is central to the way we organize our economy and our society, and of course our social and racial relations. And so within that framework, I'd just like to share a little bit about how I have made sense of this enormous aspect of American governance, which is really what it is. It's a big part of our democracy. We might say it's a destructive or an inegalitarian or failed aspect of our democracy, but it is a very powerful piece of it. And these ideas have been, we've been really talking about them now already for the last half hour. I'd just like to crystallize them a little bit. And this is, and the description that I offer and the argument that I make in my book, Punishment Without Crime, really centers on these ideas. We can understand the impact, the destructive impact of the misdemeanor system through three main lenses: innocence, money, and race. And if we don't account for each of these destructive pieces, we have missed something large about what the misdemeanor system, what it actually does to so many people. So Manel already mentioned what I think in the public defense community is a well understood phenomenon, which is that misdemeanor arrestees and defendants routinely plead guilty to crimes they did not commit. Everyone in the courtroom knows they didn't commit it. They're pleading because they can't afford bail and they can't get out of jail. They're pleading because they have children and jobs and other pressures on them that are pressing them to compromise with the system. And I just want to pull out one important piece, Mano, of your story, which I'm sure many in this webinar already recognize, but I think it's worth saying out loud. The innocence movement, and Anton, of course, as an active member of that community, the innocence movement has been one of the most important engines for change and challenge and contest in our criminal system. It really couldn't be more important. It has, however, not focused on misdemeanors. I spend some time working with attorneys in the innocence movement in other aspects of my work, and I often mention, the innocence docket that we work on of hundreds of cases, hundreds of these serious cases, are dwarfed by the wrongful conviction docket in misdemeanors. Hundreds of thousands of innocent people are pleading guilty every year. And we have not yet turned our attention, I think, institutionally and as scholars and as advocates to that phenomenon. And it's worth noticing who suffers the most from pressure to plead guilty to misdemeanors that they didn't commit. Of course, we lack data in this space. We lack data in most aspects of the misdemeanor space. But logically, given what we know about the criminal system, it is very likely young Black men, because young Black men are more likely to be over-policed for, Kayla, as you mentioned, order maintenance offenses, which are sort of this legacy of social and racial control. They are most likely not be able to afford counsel, to afford bail, to be languishing in jail, most likely for our institutions to devalue their innocence. I know your story is the story that our criminal legal system would be annoyed that a person would be standing up for their own innocence is such an affront to anything that we think our criminal system should be about. And the misdemeanor system does it every day, every day. And so ironically, the people who are most likely to be swept up into the misdemeanor system, young Black men and other young disadvantaged people of color, are the most likely to be wrongfully convicted. And I don't think we've really appreciated that harm as much as we could, and we haven't started to do anywhere near enough about it. I don't think that to this audience, and I may be assuming too much, I think that our polity, our conversations around criminal justice, ever since Ferguson, have really understood the role of money. We understand that courts, that cities, that probation departments, prosecutor offices, public defender offices have become dependent on that revenue stream from fines and fees. It's as Kayla described, it's a long legacy. The misdemeanor system represents a long legacy of wealth stripping from the disadvantaged, and our criminal and our misdemeanor system today is still driven so profoundly by money and by that revenue stream. And then, of course, neither of these phenomena, innocence or money, can be separated from the disproportionate impact on people of color, communities of color, and the meaning of racism in the criminal system. And again, I just want to double down on Kayla. I thought you put it well. The racialization of crime, this idea, this mark, this stereotype of the Black criminal that has been created over decades, if not centuries, in this country, the misdemeanor system puts it into action through disproportionate arrests, through putting people in jail, for preventing people from working. It's the way it operationalizes the stereotype, if it were. So then it can turn around and say, but you've been arrested, but you've been in jail, but you've been convicted, you bear the mark that we have placed upon you. And I don't think we can underestimate how powerful the misdemeanor system has been in perpetuating, but also generating those racist stereotypes.
Alexandra, you discussed profit as a motive that drives the misdemeanor system. But what are the implications of profit as a motive in the misdemeanor system on Black and brown people, specifically those in economically vulnerable situations?
So again, I'd like to go back to the Ferguson report, which I think really put the nation on notice, not just that the criminal system is stripping the vulnerable of their wealth and their ability to work through fines and fees, but that those policing and adjudicative practices are disproportionately levied against people of color, against communities of color, whether it's through the disproportionate order maintenance policing that we have been grappling with for decades. That's a vehicle for bringing people into the criminal system and thereby stripping them of their wealth. The over-policing of communities of color is a mechanism through which, by its very nature, is going to be imposing criminal convictions. I think it's worth noting here, we say conviction like it's the same thing as a murder conviction. It's not the same thing. It's think this conversation is a wonderful challenge to the question of whether things that we treat as misdemeanors are really crimes at all. We've seen now in the study of the fines and fees that a lot of things that people get criminalized for, they're not dangerous, they're not scary, they don't threaten anyone. It's not really what we mean by criminal. And this is my professorial hand waving that I use in class when I'm teaching criminal law. And I teach my students that the marking of a human being as a criminal is a major governance move. It's a very important, substantial move that we regulate. The Supreme Court tells us over and over again, this is an important moment. And yet in the misdemeanor system, we do it cavalierly. We do it sloppily. We do it without thinking. And sometimes we do it for the money.
Can I just jump in on that question, Kevin? I think just to add to what Alexandra was saying, I also think this is a place where the law sort of overdetermines our thinking about what is racism or what is racial bias. And it really teaches us, especially where our constitutional law is in this country right now, teaches us that it's really only like really overt, super intentional, interpersonal acts that can count as racism. And because of that, we don't really think about all the ways that we might actually, particularly actors in the criminal legal system, that it's possible that doing your job well, the easiest way to do your job well might be to do it in ways that ignore or worsen racial inequalities. Because we're not as skilled at understanding how racial bias can be the outcome of structural design that treats Black people and all racialized people as expendable, negotiable, worthy of sacrificing in order to meet other goals. And so sometimes I think that people who have positions of power and have the ability to figure out where resources are going to be spent, you can make those decisions in ways that might feel race neutral to you, but that actually have severe racial implications. And we don't think of that when we think about, oh, well, racism in the misdemeanor system. And I think we have to be thinking about the ways that, given all of these myths about criminality, the racialization of crime, that actually we think about, because we think about racism as interpersonal, we think that when it happens, it's irrational. Like people are making an irrational choice based in hatred or something else. But actually, it's, racism has quite a number of productive capacities in American society. It can help you do the thing that you wanted to do, which is really where the system of criminalization came from in the first place. So, and to give a sort of really concrete example of that, the convict leasing system in Georgia in the early 20th century, it was Black convicts who had been leased out, who built Peachtree Street in Atlanta, built many of the paved roads, started the transportation infrastructure that made Atlanta the capital of Georgia, right? And so actually the racist logic of convict leasing was very productive for the technological advancement of Atlanta. And so there are ways that some of us are positions in our jobs that actually the productive thing to do might also be a racist thing to do. And we have to be willing to confront that and to make different choices and to make sure that people's incentives in their jobs are different so that racial bias isn't sort of a logical outcome of what people are doing.
Kevin, can I stay in conversation with Kayla for a moment? Because it's so important. And I want to go back to something that Rosemary pointed out, and I'm sure we'll get a chance to talk about it later. But structural racism and these practices are not natural, and they're not inevitable, and they can be changed. And Rosemary, you're the expert on some of these questions, but Rosemary mentioned the pressure now on reform-minded prosecutorial offices when they push back against those structures, for example, by declining misdemeanor cases. They say, as a matter of policy, we're going to have a presumption that these cases will not, that that being arrested should be the end of the criminalization process. We're not going to convert you into a defendant. And I just want to point out that we do see these threads of change and reform and challenge. And I think one of the reasons they're so contested and there is so much pushback is because so many people understand that they really are very powerful engines for changing many of the destructive aspects of the criminal system. Thank you, Kevin, for letting me intervene.
That was actually a great segue to the next question. And Ruby, you were next for us to turn to around that issue of, we have seen a lot of places where reform has been initiated by prosecutors who are choosing to decline to prosecute on low-level charges. And I appreciate Alexander's point earlier that all charges are not created equal. And the way that we confound our questions of public safety and crime with charging lots of people with misdemeanors is a false equation. But we've also seen that a lot of reforms, prosecutorial and otherwise, that have been successful in reducing the numbers of people coming into the system sometimes then exacerbate disparities, where the benefits of those reforms are felt more by white people coming into the system than by people of color. Or we see the oppression being shifted around, where, you know, if we have misdemeanor reform, then charges get raised up to felonies. Or if we have opportunities for citations in the field for some charges, then charges get changed. What do you see as next steps for us to be able to ensure that changes in one part of the system don't then lead to that shifting of issues specifically related to racial disparities to other parts of the system? And what do we need to do to make these changes more comprehensive and cohesive?
That's a great question. And I wish I had a solution to that, but I don't. I don't think anybody's really solved that problem. What I will say is that I think, you know, a lot of the thread of what both Alexander and Kayla and others have talked about really gets to maybe the fundamental, more broadly, taking a step back. The first question has to be, why is the criminal justice system involved in this in the first place? What actually do we need to have in the system? Because if we can think about it as, you know, the presumption maybe should not be, this should be in the system. It should be maybe thinking about the presumption should be this system, this punitive enforcement system that has all of these historical, this really problematic, racially charged historical origins, and now is also just, you know, kind of perpetuated within the ways our societies and equities already perpetuate themselves. When we think about what should be in that system and what shouldn't be, the presumption should probably be, it should be outside of the system. That's not how we unfortunately approach these questions, but I think that's really the main first question we should have. What should we be calling the police for? Can we have an initial responder not be the police? What kind of conduct should prosecutors' offices, criminal defense attorneys, and courts actually be spending their time and resources on? Can we decide that some conduct does not need to be criminalized in the first place? Some of this conduct that we're talking about. And, you know, to the extent that that's a longer conversation, that's going to take a longer time to resolve, which, you know, obviously it's already a charged conversation that we're having about public safety in my city and other places. I think the best way to address racial disparities is to start addressing them is to think about what do prosecutors' offices, police departments, and communities know about what they're doing. And I think that a lot of what we have, you know, is assumptions about what people are doing without the data. The data is always a challenge across, you know, kind of courts and prosecutors' offices and police agencies. But when they actually start digging into that data and looking into what they're doing, and then also thinking about making it transparent, let communities understand what they're doing, which is obviously the next step and is also challenging, then we can actually get communities and prosecutors and police and court systems and defenders, you know, kind of understanding all together what is actually happening with racial disparities, and are we actually allocating the resources in the way that we really want to be doing. I think it's, you know, look, nobody's doing this perfectly at all, but I think that there are some places. For example, there's a prosecutorial performance indicators project at Florida International University that's worked with DA's offices around the country and has actually published some dashboards and reports that are analyzing racial disparities. That's the first step in the conversation. And I think that unless we engage both the data and also the public and the communities, we're not going to, kind of move beyond what we're already doing and kind of explaining why this needs to be changed. This isn't going to really change the fundamental problems, simply publishing the data and analyzing it, but at least it will help us understand what the problem, kind of more collectively understand what the problem is. But I really think the first question is thinking about, does it need to be in the system in the first place?
Thank you, Ruby. And I'd like to turn to Anton to answer that question, if you'd like to, since you raised at the top of the conversation, the importance of shifting what we're investing in and what we're able to offer people to be thinking about safe and secure communities in a different way.
Absolutely. I couldn't agree more with Ruby. I want to sort of talk a little bit about what I saw in criminal court when it comes to some of the services that were offered by the court or offered by prosecutors. And the example that I'm thinking of comes out of New York when I was in the New York felony court. And there was a drug diversion program that for clients who had drug use disorders. And I had a client who was referred to that program, and we went to the different court part to start to resolve the case, and we found treatment and all of the things. And we went back to court for a status hearing maybe a month later, and the prosecutor in that case stood up and asked the court to approach. We approached, and there was a Facebook photo that showed my client along with other young Black men or boys, frankly, is what it was, just hanging out. And the argument from the state was that was that it was evidence of gang involvement, and the court then rejected my client from the very services that he needed. And it was one of those things that, I did all the things I could do. I yelled and screamed in the moment, and we came back and filed something. But ultimately, it was up to that judge to decide how to handle that. But it was not based upon the needs of my clients. We had already done some assessments and had some clarity about what he needed. It was because of some administrative concern, something that had nothing to do with providing my client and his community, frankly, with what they needed to move on. And so when you get to these later stages in criminal cases, when you get past arrest, when you get to arraignment, when you get to the, to the diversion parts, I am all for these, right? Like we need them and we need more of them, but there are things that they cannot do. And it is incumbent upon us, all of us, to ensure that people are not getting so far into this system because there's oftentimes not a way back out of it, right? And so I couldn't agree more with Ruby in that the investment needs to happen as early as possible. And we need to challenge ourselves to remember that as early as possible means well before a person is arrested in the first place. We can look to some communities right now and determine that there are resources that are needed in specific communities. If you've heard of the $1 Million Block, right? There are communities that people target for making arrests. And to the extent that that is the case, we should be targeting those communities for the opportunities to provide resources and services. And I can tell you that, I've gone to a lot of community meetings in some of those very communities, and we want those services right now. Like we need them, and family members are standing up and asking for these resources right now. So, it is to me about just clicking out or double clicking out or backing up way before we get to the criminal legal system in the first place. I think that's the biggest way to achieve some parity in providing people services that they are begging for in many instances.
So Anton, you touched upon or spoke about community, and there's some great work happening in San Francisco. So I want to throw this question to Mano. What roles can community members play in achieving anti-racist misdemeanor reform? And how can legal professionals collaborate with communities to drive change?
Thanks for that question, Kevin. And Anton, when you brought up that example of the, your client and the photograph, one thing we've done here is I've tried a lot of gang cases, and I was sort of tired of these cops coming in and labeling not from the community, ascribing these labels to my clients without understanding the dynamics. And I had this regular pickup basketball game in a part of the San Francisco, and there was someone who did a lot of youth work coming, and he said, was breaking it down and how, the stereotypes can play out. And, and I said, I need you to come to court and say that, and be my community expert. And we started basically having community or cultural experts to counteract their gang task force experts. And what I found is that the jurors are very hungry for that kind of information, localized expertise to actually break things down. And that's been very successful. And I remember the judge saying, well, he's not a gang expert. And I said, that's fine. My client's not a gang member. My client's a community member. They can call their gang expert. We'll call our community expert, and we'll let the jury decide. And once we got, in this case, him qualified, now we've started to replicate that in other areas. So that's a little broader than just the misdemeanor system, but I think it's the type of thinking we need to start doing. And, it's interesting that all the resources, we often go to the court or the prosecutor for these services, whereas the reality is with the Fifth Amendment, we're the ones who can actually talk to the people legally, the only ones who can legally talk to the individuals that we're trying to provide services for. So what we started in San Francisco is a program we're calling the End the Cycle program. Of course, we could use more funding, but so as soon as people hit the jail, to have social workers, culturally competent social workers connecting people from that moment with services. Because there's the misdemeanor churn, but there's also the churn of people who may get arrested, put in, and then let out because it's too minor for even a prosecutor to actually file against, but there still might be some underlying issue that can be addressed there. So the thought is that if we have public defenders actually combining with community-based organizations and collaborating with community-based organizations, whether it's a mentor, whether it's labor, substance abuse counseling. We started a program with Cal State and City College here, college prep program to get people enrolled in a college class. Like, start doing those kinds of things that'll put people in a more positive direction without waiting for the prosecutor, without waiting for the court, without waiting for anyone. Just start addressing that need, and then maybe going back later on and saying, this is what's going on. You should actually dismiss this case for this individual. So I'm really interested in us as, sort of taking the charge and not waiting for the courts or the prosecutors to sort of reform, and start trying to make as many of these moves as we can, and then asking them to come along and join if they're interested, But, it's really, we've touched on Ferguson in the article, touched on George Floyd, but, we see a public execution, and then it causes us to go back and look deeper at all the issues in the system. In George Floyd's case, this was a alleged counterfeit $20 bill that started this whole thing, right? So I saw in the chat some questions about restorative justice, like, why don't we have a restorative infrastructure in that community, maybe between merchants and the community, to say, listen, if there's something that is surely a property issue, let's call so-and-so and have them work it out. You think someone owes you $20? Okay, let's deal with it in this realm, as opposed to, a misdemeanor realm. I mean, if it had to go back past that, why isn't that just a citation to a small claims court? Hey, by the way, he thinks it's a 20. I don't know if it was counterfeit or not, but show up and, sort it out in small claims, as opposed to, what we had here was, I'm going to arrest you for this, essentially a misdemeanor, and then actually execute you because I'm going to say you're resisting. So there's so many layers to this, but I think we have to be willing to go deep enough into the layer to address the underlying issue in that transaction. But to Ann's point, let's talk about earlier job creation, educational inequities, all that before we even get to this level here, and then start doing the data on that. One of the problems with this, one reason we don't have the data is the data, it tends to be the police and the prosecutors who get the money for the data analysts. I finally this year was able to get one data analyst. And of course, everyone in my office wants that person to cover every single issue, but we need data coming from other perspectives too. So when we say we need to look at the data, we need to figure out who's actually generating that data, and can we have other people with the opportunity to look at data and more data points.
Thanks so much for that. And I'm loving all the threads that you're bringing up in terms of, this is not a one-shot solution. We need to remember the humanity of the people that we're working with and the stories of the folks who are impacted. We need data from our community and from our system to be able to help us get a big picture of what's going on. And I really appreciate that point, Minnow, of people from the community being hungry for this information, that we so often get caught up in media narratives around crime and forget the fact that most folks want to understand the nuance. And as people who live in the communities, they have been impacted by crime. They know people who have caused harm. They get that this is a complicated issue that needs complicated conversation and complicated solutions. And as you all have brought up, that most of those solutions are grounded in community spaces rather than being grounded in the structures that we've built in the criminal legal system. And we have some wonderful questions that have come up in the chat box related to some of those issues. And Minnow noticed the question about restorative justice, and I just wanted to give everybody else a chance to weigh in on that as well, because I know that it's not a subject that gets as much airtime as it should in terms of what are the other ways that we have to be able to resolve conflicts in our community outside of the criminal legal system. And if anybody else wants to jump in on great examples that you've seen or ways that you see restorative practices being able to play out as an alternative to the misdemeanor process.
Yeah, I'll jump in a little and talk a little bit about it. I think one of the really beautiful things about restorative justice and restorative practices is that our criminal legal system, the sort of questions that it asks are like, was a crime committed? Who committed it? How should they be punished? Whereas restorative justice asks, was someone harmed? Who was harmed? How can we collectively restore the harm, repair the harm that was done? And part of why I think that shift is so powerful in the misdemeanor space is because at the very first question of like, was anyone harmed? It really reveals the sort of victimless nature of so much of the misdemeanor system. It helps us to immediately ask ourselves, like, why are cops even intervening in this situation at all when there's no harm that has been done? And then opens up space, whether there's a victim or not, it opens up space in answering the question of who was harmed, where actually it can be both the victim and the person who we would imagine as the defendant who have been harmed by some sort of structure in our society that made this interaction between them more likely to happen, right? From the counterfeit bills that people might use in order to buy food for their kids because their kids have to eat, whether or not they have money. And so we see a lot, some of what happens in the misdemeanor system is that we're criminalizing poverty. And when we start to ask questions about, well, how do we repair harm? We can think about, well, how's our money being spent? Why is it that we don't have money to spend on affordable housing? Why is it that we don't have money to spend on a really robust social welfare system? And as much as the criminal legal system can feel like this place where we're sort of powerless, these things are hyper local, right? These are places where civic engagement can really make a really big difference. And people can start to think about, well, how is my city budget being used? How much of that money is going to law enforcement, which means that anytime something happens, the only people who have money to respond is the law enforcement agency, right? Where did our COVID recovery federal dollars go? Who actually got to spend that money, help in ways that help versus ways that punish? And so I think restorative justice opens up sort of all of these conversations, because instead of thinking about punishment, we're thinking about how do we actually repair harm, and everyone gets to count in who's being harmed, not just, you know, certain people amongst the group of folks who might be victims.
And I appreciate that point, that restoration can happen on the interpersonal level, and it can also happen on the structural level as well, if we step back and think about what are our broader opportunities for repair. We had several folks in the chat box go back to the plea bargain question. And what do we need to do to both change the structure of our system that relies on plea bargaining? And then someone who also asked, what would it look like if we actually gave everyone the resources to bring their case to trial? And how would that change the way the system looks? So is there anybody that would like to speak to the question of plea bargaining and what we need to do to change that reliance in terms of getting guilty pleas, as well as it being a measure of success for courts and for prosecutors?
I'm happy to start the conversation. There's talking about plea bargaining is like saying, let's talk about the American criminal system. It's so large, we couldn't possibly encompass it all. But I want to go back to a point that has been touched on a few times, that be careful what you ask for, that sometimes reforms turn around and bite us. And in the academic literature, we call it net widening. In other words, there are reforms and changes that might even look lenient, right? They might even look better for defendants. Plea bargaining is the largest one, in the sense of, oh, we're going to let you face a lower sentence or less punishment, or, you know, work out a deal on the assumption that otherwise you would face more serious punishment. But probation is a net widener. Electronic monitoring is a net widener. Diversion is a net widener. All of these reforms, which are often introduced as well-meaning, progressive ideas to make the system less harsh, actually make it easier to sweep people in, easier to convict them, easier to punish them, and not only easier, but cheaper. So plea bargaining, the fact that we permit the government to negotiate people's guilt, you know, is a philosophical decision that the American criminal system has made that many other countries do not. Many other countries think it's unseemly to haggle over guilt and to permit the government to exert its considerable coercive authority to get people to agree. But given that we've made the decision, we need to see that it permits the size and the scope and the intrusiveness of the criminal system we have. We couldn't afford to run a system this large if we didn't have plea bargaining. We couldn't arrest and process and prosecute as many people as we do if we didn't have, in effect, this safety valve. And again, just on Megan, on that question of resources, again, we could talk all day about the lack of resources on every front, but I just want to, so many of my students aspire to become public defenders, and they all want to work in Menno's office, as far as I can tell. But I just want to point out that the thoughtful and engaged and sophisticated engagement that Menno just described, getting a community expert and bringing them to testify, that requires resources. The San Francisco PD office is a famously fantastic office. And many public defenders' offices, they don't have that. Their lawyers don't have the time. They don't have the wherewithal. They don't have the time and the resources to go get an expert to challenge the infrastructure of criminalization before it starts. So if we're looking at the gold standard of thinking through how we might challenge it, we need to recognize that we are not funding American public defense on the scale that would be required to make that possible for the average American defendant.
Yeah, thank you for those kind words, Alexandra. And we absolutely are not. I mean, the reality is we need more of us in pretty much every department, including mine, where we're only 61% of the district attorney's budget, let alone the police, sheriff, probation, and everything else, right? But I think to that, yeah, the plea bargaining is a major problem. And one thing we need as a defense community is actually, when cases are filed, to really push back, to try to avoid the conviction by any means there, to develop cultures within public defender offices where you feel bad about pleading your client, even though it's a psychological shift. We actually keep track of plea ratios, both in our felony unit and our misdemeanor unit, and we want to make sure that the plea ratio is down, that our clients are, even though it's net widening, and we want to avoid a lot of these things that are going to diversion, ideally shouldn't come into the system at all. But once they're in this system, we'd rather have that than a conviction, or we actually want, to push back and say, listen, we're going to keep on trying cases and, have everyone work on, frankly, all the different aspects of trial. How do you do a powerful opening statement? How do you marshal the evidence, cross effectively? So just make it painful for the prosecutors to realize you're not just going to get convictions against our clients. We're coming back. We're going to try and make sure to level up everyone's trial skills and really push hard back in the system. Simultaneously, we have to work on other things. So we managed to get funding for a small policy unit now. And so we went to Sacramento, our state capital, and said, listen, we got to put a cap on some of these probation terms, because so many times it's so easy for the prosecutor to say, plead guilty today and be on probation paperwork for 5 years. So now we went to Sacramento and said, for a lot of misdemeanors, the cap is now 1 year. For a lot of felonies, now the cap is 2 years. I'd like it to be even lower than that. But then it's incumbent upon us for the line deputy to say, okay, the cap is 1 year. Well, I don't want 1 year. I want 6 months, or I want 5 months, or I want 4 months. Now that we, on the structural level, gotten a cap for those. So I think we always have to try to fight on both levels and try to make sure our community partners and allies understand what it is that's happening, because so many people don't understand the everyday reality of what happens in a criminal court. So we actually, I'm actually elected too. So I'm out there talking to people all the time. And that's another big issue in our country. So few of public defenders are actually elected. We have elected prosecutors, we have elected sheriffs in every county, and only a couple. I'm the only one in California who's elected. So I'm trying to really push the envelope. But we reached out to the community and got a lot of community members to write letters to City Hall, to the Board of Supervisors, advocating for more funding for public defender offices. And these are some of the constituents that are then going to vote for those supervisors. So I think we have to be really creative and make sure we're not only dealing with the criminal legal system within the traditional confines of those who are, people call quote unquote justice partners, but reaching outside to community, which frankly, our clients are much more connected to anyway.
If I could just add, education is so important, but we also need to educate the public to understand what it means to plead guilty, what our trial system looks like, how it's overburdened. If I could tell just one public defender story, I had a client, this is many years ago, and I was a federal public defender, so he was charged with a federal offense when I first met him at the jail, and he said, just get me the best plea deal you can. And he had a record, he had been through the criminal system before. And I said, okay, sir, but also we're going to talk about the motions and we're going to talk about trials. He said, no, just get me the best plea deal you can. I come back to the jail with more research, we talk about it. He said, no, just get me the best plea. Finally, the third time I come back and I say, sir, it is your choice to handle your case the way you want to. Let me just ask you one question. Have you ever seen a trial? He said, no. I said, do you know what a trial is? And he didn't know. He had been through the criminal system and he had been so acculturated to the assumption that he was gonna plead guilty to something that he didn't. And so I just want to keep in mind that the public needs to understand that even though 95% of all the criminal convictions in this country, not just misdemeanors, felonies too, are the result of a plea, not of a trial. We almost never go to trial in this country. The trials that everyone sees on television, they're literally fiction. It's so rare for us to go. And I think we can do a better job of educating people and communities and the public about what a huge loss that has been for the integrity of our governance.
%. And I think one of the things that prevents that is also the trial tax with judges and prosecuting. You don't have to take this deal, but if you exercise your constitutional right to trial, I'm going to hammer you if you're found guilty, right? And that coupled with pretrial detention and overcharging has led to such a decline in jury trials.
Anton, did I see you jumping in?
Yeah, I'll just say I've experienced that so many times I can't count, where the client has said to me, you know, upon meeting them for moments, like, hey, I want to plead. What can we get? You know, how do we resolve this very, very quickly? And it's unfortunate, but it happens all of the time. And pretrial detention is really a big driver. Obviously, we know that if someone is held in pretrial, then they're more likely to be found guilty. They're more likely to have a harsher sentence, and to have the harshest outcomes in the case as well. So just thinking about those factors are hugely important. I'm glad we're talking about it.
Thank you all for that. And I want to circle back to the point that Alexander made at the beginning of that question around the unintended consequences that a lot of our reforms have. And as somebody who's been guilty of this for the last 20 years of my career, where I remember when rocket dockets were a reform of like, well, if we can just move things more quickly, you know, isn't that helpful for everyone? And another way to get people out of jail. So what do we need to do to break the cycle? How, as we move into whatever our next generation of reforms are, what do we need to do to make this different so that we're not recreating the same oppressions that we've been recreating for the past 150 years with whatever we go to next? And I feel like we'll all be able to retire once we can answer that question.
I'll jump in on one example just to get the ball rolling. You know, again, one of the things that draws a lot of attention to the criminal legal system is from our side is often when a cop shoots or kills someone. And sometimes there's an incentive for people like, oh, we got to get that cop prosecuted. And while I understand that incentive, for our client base, I think what's more important is to stop those kinds of detentions that lead to that in the first place. You know, and so we went through a strategic visioning and brought in someone from another organization, the Asian Law Caucus, actually in San Francisco, to lead our policy, comms, local and state policy function. And in collaboration with community, we were able to push the police commission to pass one of the more, if not the most progressive policies regarding pretextual stops, right? Which often leads to the violence, or even if there's not the trauma of everyone who stopped in the vehicle, and then often a lot of charges, right? So to me, that's the kind of initiative which actually eliminates the police's ability to detain and arrest on particular offenses to begin with, which is then hopefully going to shrink the number of charges that are filed and shrink the absolute, this kind of trauma. So I think just starting to move in directions like that to concrete things that can actually shrink the system is a direction that we need to move in. At the same time, while the system is there, I think from our end, we need to push as aggressively as possible to figure out how to defend someone at the highest level, whatever that means, and really working on that. And to the point some people made here, oftentimes it is that relationship that we have with our clients at the front, which is the most important relationship that can determine, like if you have a better relationship with your client, you can probably fend off a bad plea bargain better than if you don't have that solid relationship. So really emphasizing connecting first with your client before doing anything, at least from the public defender perspective.
Thanks, Minnow. Anyone? Kayla.
I really appreciate the point about shrinking the system. I don't think we can emphasize that need enough to just reduce contact with the system as much as possible. And I think, Manu, you talked a little bit about sort of like indignities that happen in the system. And that's something we've talked about a little bit. And I just want to talk about a little bit more, because I think sometimes the sort of changes that get recommended to the system are about process and procedure. And you might say, well, you might have been arrested, but at least eventually the charge got thrown out. But that arrest is like a major, significant, traumatic event for the person who experienced it. And even if the arrest gets thrown out every time, being arrested multiple times in the course of your life when you've done nothing wrong is a harm that has to be a part of what we're talking about when we talk about more an anti-racist system and more equitable outcomes. And so I think we have to really be focused about assessing impact through changed outcomes, not just that like we've added a process or procedure so we might feel better about outcomes that produce racial inequality, but actually that the racial inequality has to change. And if that doesn't change, then we haven't done our jobs yet. I think is a really important piece for us to walk away with. I know sometimes we talk a lot about the need to sort of build trust in the criminal legal system. And I'm hopeful that we can spend more time collectively talking about what it means to build government institutions that are worthy of our trust, and that this is a part of that work.
So to that point, I would like to pose one final question. We could share final thoughts as to what those working towards systemic change, what can be done? What next? How can we create a system that is anti-racist, that produces more equitable outcomes, and still realizes safety for all, especially for Black and brown communities who we know are disproportionately impacted by misdemeanors?
Just I want to double down on everything that Menno and Kayla have been saying about shrinking the system. I really think that's key. Fewer offenses, fewer people, fewer arrests, fewer jails, fewer convictions. Just the metastasization of if we keep it in our sights, I think that is the spirit in which we will be able to evaluate whether change, as we sometimes call it, are non-reformist reforms, or if they're really net wideners, and actually we're going to regret them, in 5 or 10 years. I'd just like to put two mechanisms that I myself have been thinking about recently that I think are of that ilk. One is, and Rosemary mentioned this a little earlier, and I just want to mention it again, police are not prosecutors. They're not supposed to be. They're very, very different jobs. And I think that our experience with decades of mass incarceration has dulled our sensibility about the difference between those roles, and many of these reform-minded prosecutors are reminding us that they do a different job than police do. And the first mechanism through which prosecutors get to do that is the declination decision. In other words, people are getting arrested and the prosecutor says, that's enough. We're not charging that case. And so one thing we can do, I sometimes talk to judges, and judges say, what can we do? And I say, go back to your jurisdiction and ask your prosecutor office, what is their declination rate? In other words, are they rubber stamping arrests and just passing them through, so now everybody has to pay those costs? Or are they doing their job, essentially, the basics of a prosecutorial job, which is to screen those arrests and really screening them. And when they do screen, of course, by definition, we see fewer people in the system, but we often see racial disparities decline. The lack of screening is often itself racially disparate. So I just want to put a plug in for noticing that moment when policing becomes prosecution, when policing becomes the formal adjudicative system, that we can intervene at that moment, and we can ask prosecutor offices, how are you standing at that, on that line, and how are you declining cases? And I think the precedent is there. Many prosecutor offices have done that. The second thing I just put on the table, which is a little bit of a different ilk, is electing judges. especially municipal court judges and local judges. Another thing that we learned from Ferguson, that a lot of these judges are, elected by the city or appointed by the mayor who is elected. And local communities can have a lot more influence over the election of a judge in a city than they can have over a state judiciary system. And I don't think we have fully appreciated how educated communities might intervene in their own criminal systems by running slates, by engaging the political process for accountability for the criminal judiciary itself.
Yeah, I don't want to just to sort of follow up on a few things that others have said. I really do think that it really takes our communities, and going back to the question of engaging communities, reframing what we think works and doesn't work and what that means. Because, I think oftentimes, and, just speaking from the perspective of law enforcement that's trying to possibly reform things, you'll hear about someone who's suspected of committing a crime and read that person has a long record and cycle through in and out of offending, arrest, incarceration, reoffending. And often the conclusion, broadly taken, at least in the public media conversation that we have about this, is, wow, that person should have spent more time in jail or gotten a longer sentence. Not, oh, wait, maybe the arrest and incarceration aren't actually preventing reoffending. Like our concept of what is working in this system and how it works is really distorted. And I think we need to really be having conversations with the community about what actually the system, arrest itself, incarceration, obviously, detention, all of those things impact families and communities. And I think it also is a question of engaging all parts of the community in our public conversation, because definitely there are things that we hear about in the media and others that, I think there are members of the community and voices and perspectives that are not necessarily surfaced when we talk about what we mean by public safety. And so I really think it takes a really close look at what we mean when we say we are going to be improving public safety. And I do think that we also need to do a lot more in talking about the costs of system involvement. I know the Brennan Center has done reports on that. I think there have been reports and evaluations of the impact of non-prosecution of misdemeanors and how it decreases the likelihood of subsequent criminal justice involvement, even compared to being involved in the system. But somehow or other, the default is still the system works, which, the fact is that if you think that reoffending or not causing crime, preventing crime is what will work for public safety, the system isn't really working. So I think we need to just take a broader look at that.
Rosemary, you just spoke a word. Thank you for that. And thank you to all the panelists for the perspectives that you have shared. This was incredibly powerful and insightful, and we're looking forward to continuing this conversation. For those tuning in, the panelists also provided feedback to support the development of the paper. So we thank them for that as well. And we invite them and the public to continue this conversation and to keep the momentum going. Let's keep the history of how misdemeanors came to be in mind as we move forward. Let us embrace the anti-racist principles that we explored today and remember our collective responsibility to advocate for reforms that are grounded in anti-racism, accountability, and safety. And let's work together. We invite you and your partnership to those who are interested using the local anti-racist pretrial justice framework. PJI works with community coalitions, local governments, and justice reform collaboratives to understand pretrial processes and support local action. As discussed quite thoroughly on this call, in this roundtable today, we partner with places looking to strengthen the footprint at the formal pretrial system, build community power, as discussed during this roundtable, and amplify community voices. We provide system assessment and process mapping to help stakeholders evaluate the system, right, and understand how their pretrial process currently functions. We provide policy review for draft legislation, court rule, and pretrial policy. Data analysis, as is brought up on this roundtable discussion, which is so vital, right, to pushing the needle and really orienting to systems change. Finally, we provide implementation support. So we invite all of those who would like to partner to reach out to us, and let's work together to improve the system. We hope that you read our misdemeanors paper, and we invite your feedback and conversation on that as well. Thank you so much for your active engagement and your contribution to these critical conversations by attending this roundtable. You all enjoy the rest of your day, and thank you so much.
Thank you, everyone. Take care.
Thank you.
Thank you, everyone, for connecting.
Thanks,
We'll
everyone.
get that back to you, Mano.
Yes.
Please do. Please do. Look forward
Thank
to
you.
it.